Good afternoon and welcome to Airbnb Do's and Don'ts in San Francisco with Michael McLaughlin. Please let me introduce the president of camp, Mr. Kevin Casey. Kevin.
Good afternoon. Welcome professional mortgage professionals and guests. I imagine we have some real estate agents and some Airbnb people on this call. Today I have the privilege of having Michael McLaughlin on. I've heard his presentation a few years ago on Airbnb in San Francisco, and it was so fascinating to me. Just all intricate little details, and it's actually allowed me to help many of my clients who are thinking, oh, well, listen, I'll buy this house and we're going to turn this downstairs into a little unit and rent it out and get Airbnb income. And I'm like, no, you're not in San Francisco. It's not going to work what you're thinking. And it's because of Michael McLaughlin's presentation I've learned this. So I wanted to pass this information on to everybody. It's for San Francisco specifically, but a lot of this flows into the rest of the state of California. So with that, I'm going to introduce Michael McLaughlin. Take it away, Michael.
Kevin, thanks so much for having me. And good afternoon, everyone. This is one of my favorite subjects. I have to tell you that I've been dealing with, the share economy in housing now for, I don't recall exactly when I first got involved with an enforcement action. It was probably 7 or 8 years ago, far before the current San Francisco ordinance was in place. And we're going to talk all in a lot of really gross detail about the San Francisco ordinance, but let me just tell you that in the old days, in the Wild West, and then Megan, I think we can go to the first slide here. We want to just advance that slide. Okay, there we are. Okay, that's great. Yeah, it's the one that should say until February 1st. Yeah, there we go. Okay, so prior to the enactment of the existing short-term rental statute, doing short-term rentals in San Francisco was just illegal. It was prohibited by the planning code. And it's important to remember that it is still illegal in San Francisco to do short-term rentals, which are rentals of less than 30 days, unless you comply with the statute. So, and that's true whether you are renting the room or the apartment or whatever it is that you're renting out on a platform, a really well-established platform like Airbnb or VRBO, or whether you're just out on Craigslist, or you're you're really super old school and you write out a postcard and you thumbtack it to a bulletin board at Safeway. It doesn't matter how you are finding your short-term guests. If you're doing it without complying with the ordinance in San Francisco, it's still illegal. All right, the planning code prohibits it unless you comply with the statute. So Megan, why don't we go ahead and flip to the next slide. And here's our friendly officer. Let me just give you a cautionary tale of the old days. The old days is that if you had a neighbor that was complaining that you were doing short-term rentals, they would literally send enforcement officers out to the unit, and they had the right to essentially go in and inspect the unit. They could get an administrative warrant if they needed to. And I went on one of these enforcement actions before, and they were really quite serious. I mean, there were 2 enforcement officers. They came out, they looked at the mail that was on the table. They looked around to see whether the guests' belongings were put away or whether they were still laying in a suitcase. So they were really making sure that, this was a bona fide lease for longer than 30 days. And they've kind of carried that over, that enforcement mentality at the planning department. I say that even now that we have the ordinance, and some people on the call may be familiar with some of the people who work at the planning department, Omar and Kevin, his boss, they take their job seriously because they are an enforcement agency. The planning department actually enforces the planning code. And so long as you stay on the right side of the law, and you are actually in compliance with the ordinance, you should be okay, and it should be a boon. You can do really well working with Airbnb and VRBO and even off Craigslist and whatever. But the tail here is, and the real important thing is you got to comply with the code. Now, as a result of some litigation now, it's very hard to list your unit on the established hosting platforms unless you're in compliance. You actually need a registration number to go and do that. And that's been just the way that, and so, like I said, I've been doing this area in San Francisco now for about 10 years. And it's just the natural evolution of things. Things have become relatively settled now. Everybody kind of knows that there's a planning department and there's an office of short-term rentals, and there are certain requirements that you need to go, and you need to get a registration certificate, and you need to be in compliance. So it's really kind of rare anymore for me to see people who are, you know, off in the weeds. It used to be a lot of that, people trying to game the system and see what they could get away with. I'm not seeing a lot of that in my practice so much anymore. So let's go and dig down into what the statute allows. So Megan, if we could run down to the next slide. So here's essentially big picture what the San Francisco code says. The code now, the planning code now says that permanent residents, and you'll see that's in air quotes, can rent their primary residence, again in air quotes, for short-term residential rentals, again in air quotes. And whenever you have a lawyer who are putting big capitalized terms in quotation marks, you should know that these are defined terms. So we need to go in and take a look at what each of these terms actually means. So Megan, if we could slip to the next slide. So let's take the first defined term here. Who is a permanent resident? So remember, we said that permanent residents can rent their primary residence for short-term residential rentals. So a permanent resident is a person who occupies a residential unit for at least 60 consecutive days with the intent to establish that unit as his or her primary residence. Now, what's really important to keep in mind, and this will be in, we'll get into some more of these details down later in the presentation, is that a permanent resident can be both an owner or a tenant. So tenants can do short-term rentals. They can get a certificate to do short-term rentals. And we'll talk about what some of that looks like vis-a-vis HOA, CC&Rs, and also leasing issues. Okay, so we'll talk a little bit about what happens when a tenant engages in, I call it Airbnb type activity, but it's really any hosting platform. It could be VRBO, it could be Airbnb. But Airbnb is just the 800-pound gorilla, and it's just how I refer to short-term rentals, okay? So anyway, it's somebody who occupies that residential unit for 60 consecutive days. And here's the rub, with the intent to make it your primary residence, okay? So let's go to the next slide, Megan. What is a primary residence? This is a very important concept under San Francisco law. It comes up under the rent ordinance. It comes up here in the planning code. The primary residence is your usual place of return for housing, okay? You can only have one primary residence. Let me give you a quick little story. I had clients a few years ago. They actually owned 2 single-family homes in San Francisco, one out in the Sunset and one in the Mission. And they applied for an Airbnb certificate and got denied because the planning department said you can only have one primary residence, and we think your primary residence is the one out in the Sunset and not the one you're trying to get the certificate for in the Mission. Okay, so that it can be a big deal. It can be a make or break, determining what your primary residence is. So the code actually tells us, how do we prove that? Like, how do you prove that this is your primary residence? Well, there are a couple prima facie indications of your primary residence. One is a vehicle registration. Another is what address is on your driver's license. Another is whether you're registered to vote at that particular address or another one. Tax documents, whether you take a homeowner's exemption on one particular piece of property, that's a really good indication. And also utility bills. Are the utilities in your name? One of the lawyers who taught me when I was a very, very young lawyer had a very common sense way of determining what is your primary residence. Like, is this one your primary residence, or is it the other place that you own? And he said this, he said, it's the place you go to when you get off the plane at SFO from vacation. Where do you go to? Which house do you go back to? That one is more likely than not your primary residence. So you can get your driver's license and the voting and all this, that's the important stuff, but the common sense stuff is where do you go when you come home from vacation? That place that you usually go to, that's the one that's probably more than likely your primary residence. And I told my brother something a few years ago. He was trying to, in a totally different concept, trying to say, well, I'll just say this, I'll just make this up. And I said, you need to know something about lawyers and judges and people in enforcement agencies. They've heard it all before. They have absolutely, you will not be able to trick them more than likely. They're very common sense people, and they have a way of just kind of sniffing it out. They'll figure it out no matter what sort of game you decide you're going to concoct, because chances are you're not the first person that came up with this idea.
I knew a guy who was trying to evade California residency for property tax purposes. He was saying that he was living in Nevada, and they just pulled all his cell phone records and showed that he was in California more than 50% of the time, and they hit him with a huge tax bill.
Yeah, no, it can be enormous. So that's kind of it. So just to recap there, where your car is, where you're registered to vote, your driver's license, more often than not, it'll be obvious which one's your primary residence. It's unusual to have someone that owns, 2 single-family homes within about 5 miles from each other, and there's sort of it can happen. I've had that come up, but very often somebody will have a place either in Tahoe or out in Arnold or in Big Trees, and they'll have a place in the city as well. And it's pretty clear which one's your primary residence. But just know
that's in the mortgage world when they, oh, I want to get a primary loan on my secondary property. So yeah, we deal with that all the time. That doesn't sound. Where do you work? So you can't be making your Tahoe place now something your primary if your work is near your, just little things like that. Where your kids going to school.
Right.
Yeah.
So let's talk about this. Now that we've established that let's say we've established pretty clearly that this one is your primary residence. Here's the biggest issue in Airbnb and doing short-term rentals and getting a certificate. Bar none, this is the biggest area of contention. And that is, you have some sort of in-law in the basement or some space in your primary residence that you want to use for short-term rentals. Because let's say that you have a 3-bedroom, a single-family home. It's a 3-bedroom. You've got a master bedroom in the corner, and then 2 units right next to you. Very often, people are like, I don't want to be in the same unit with these people that I don't know, and they're literally like in the bedroom next door, right? But some people say, oh, but I've got this downstairs, and it's got a separate entrance, and it has maybe a little kitchenette in it, and so I can just put them down there, and I can close and lock the door into the upstairs, and they can be down there, and they can come and go, and everything is going to be great. The problem with that is that's considered a separate dwelling unit, and that you can only have one primary residence. And so that 98% of the time, that's the issue that gets people denied a certificate. The other 2% is some combinations maybe of that, and they'll have a code violation of some sort on the property, and we'll talk about that in a minute. This is really the rub, though. This is really where the rubber hits the road in getting a certificate and getting the okay from the planning department to do Airbnb. No matter whether the unit is legal or illegal, and I will say this, if you have an illegal in-law downstairs, and there are 80,000 of them in the city of San Francisco, so I see this in my practice almost every day. You can't get a certificate, a short-term rental certificate if you have an illegal unit. It's just against public policy. It's against the statute. You're not entitled in any event to rent that out for housing purposes under California law. So let's say, and I'll give you a real-world example, Kevin. I had a property investor working with a very, very close realtor colleague of mine. Beautiful, just a beautiful place, a beautiful downstairs, just this amazingly great. I mean, it was like the ideal Airbnb type situation downstairs. And the realtor and the investor came to me and said, "Hey, we really like that. We really like this, and the buyer wants to just be sure that he can count on what we think will be pretty substantial short-term rental income, right? And I was like, wow, it's really beautiful, and it has a certificate of occupancy. It's great. The only problem is you'll never get a certificate for this, no matter how beautiful it is. It has nothing to do really with the quality of the workmanship, whether it's a legal unit or an illegal unit. The key issue for the planning department is going to be is that it's a separate dwelling unit, and therefore it's not your primary residence. So no matter whether it's legal and how beautiful it is, and this place was beautiful, I had to tell the investor it's not going to work. So if you're counting on that, I wouldn't make this investment decision based on that expected stream of income, because you won't be able to do it legally. And you might be able to get away with it for a little while, but it will get cracked down on. They're really good at finding this stuff. So that's kind of one of the most important elements of this presentation tonight, is that concept of your primary residence. Megan, why don't we go ahead and get off that topic for a minute and move on to the next slide. And that is, well, the next topic here is, what is a short-term residential rental? So a short-term residential rental is it's tourist or transient use, which is 30 days or less than 30 days, that is offered by a permanent resident. That the person offering the rental has to be a natural person, so it can't be an LLC. And the unit has to be registered with the city, okay? And it cannot be, this is an important point, it cannot be, say, a BMR unit in the inclusionary housing program. You would be surprised how often I see this issue come up. It comes up a lot. Do not ever do this. It is a world of hurt. It is really bad. The mayor's office for inclusion, you know, the mayor's office for housing enforces the rules against renting out below market and inclusionary housing units really strictly. I've seen some really nasty stories and really nasty cases on that. You definitely don't want to do that. If you have a BMR unit, no matter how beautiful it is and how much you think you can get off doing short-term rentals, please don't list those for short-term rental, or frankly for any rental. They're just not, it's just not allowed. And the enforcement actions are steep and really scary. All right, so now we'll get on to the 6 requirements for compliance. So these issues I'm going to go into now are the issues that are probably familiar to a lot of people, including a lot of people on the call. These are the things you have to actually establish when you go out and you go down to the Office of Short-Term Rentals and make your application for a certificate so that you can get onto the AirBNB platform. Let's go through those. You've got to register with the city, right? So that's the first requirement of compliance. You've got to maintain liability insurance of not less than $500,000, or get that liability insurance from a hosting platform like Airbnb or VRBO. You have to name the owner. If you're a tenant, you've got to name the owner as an additional insured. You've got to maintain compliance records for 2 years. And what does that mean? Believe it or not, you actually have to establish and maintain the records to show the number of days that you were in occupancy of the unit. And why is that? Well, the reason for that is the next item for compliance is you've got to occupy the unit for no less than 275 days out of the year. Okay, so this is where we need to stop, and many of you may be familiar with this, but the rule in San Francisco is that you can do unlimited number of days if you're in the unit with your guests, but you're limited to 90 days if you are not in residence. So if you're not going to be present while the occupants are staying in your unit, the short-term renters are staying in your unit. How do we know that? Well, if you take 275 days, that's the number of days you've got to be in your unit, and you subtract that from 365, you'll find that the number is 90. So it's 90 days. If you have to be in occupancy for 275 days, you can be out of occupancy and have somebody else in there for only up to 90 days. But if you're in occupancy 365 days, then you can do up to 365 days of having guests staying with you. Okay. You have to pay the applicable hotel taxes, and you can't have outstanding code violations. Okay, those are basically the 6 requirements of getting a certificate. Some of these become the insurance ones. Let me touch on that for just a second. I'm not an insurance guy necessarily, but I have a litigation practice and I see people get sued frequently. One of the most important things that anybody can do with respect to owning real property is to have adequate insurance in place. I always recommend to my clients, please, please, please have a discussion with your financial advisor and your insurance broker before you do anything. Get the proper insurance in place, and be sure when you're having that discussion with the financial advisor and with the insurance broker that you tell them everything and that everything that you tell them is truthful. So if you're not living there and it's a rental unit, that's okay. Tell them that so that they can give you the appropriate policy to fit that circumstance. Because if you don't tell them something material, when you have a claim, they can either deny it because you weren't truthful in the application process, or they've given you a product that doesn't fit the circumstance. So if you don't tell them that this is a rental property, they may give you an owner-occupied property and it won't cover you. It won't have the coverages. It won't have, for example, wrongful eviction coverage. It may exclude coverage for claims made by people who are renting the property from you. So really, really important. You can get the minimum coverage, from the hosting platforms, and that's fine. But I want to take the opportunity to really drive home how important I think it is that people be properly insured in their property. I have had more than a couple of clients, and I have a couple of active clients now who were not insured. And now they've been sued. And what that means is that you are footing all of the legal bills, and if we go to trial and you get a judgment against you, you're paying the judgment out of your own pocket. Or if we go to mediation, which is more than likely what's going to happen, and we're going to settle for some factor of tens of thousands of dollars, whatever that settlement is coming out of your pocket, because there's no insurance pool of money there. So I just can't emphasize enough how much I think insurance is important, and that's my spiel on that. So if you take nothing else away from this, please go and make sure that your property is adequately insured. Okay, so those are kind of the basic rules. I think they're relatively, in San Francisco, they've kind of become well known. Most people know that you can do unlimited rentals, short-term rentals, if you're going to be in possession at the same time with your guest. You're limited to 90 if you're not going to be there.
Okay.
Right. Okay. So let's move on to a couple of other little details of doing short-term rentals. First of all, is how much can I charge? Is there rent control on short-term rentals? The answer is no, there's not. You can charge whatever you want. You can go out into the marketplace. If you think that a guest is willing to pay $395 a night for your place, you can ask for $395 a night, and that's fine. There's no minimum or maximum. The only thing on this point that I will say is, if you're a tenant and you go out and rent this, you cannot take more per month than you're paying to the landlord. Okay. Yeah. So if there are any tenants on the call, this rule kind of applies to you, but only halfway. If you're only going to rent the room or the apartment for 2 nights a month, and you want to charge $500 a night, and you can get that, and you don't pay any less, you pay no less than $1,000 a month to the landlord, you can do that. But just know that you're not legally allowed to charge more per month from your guests than you're paying to the landlord. This is an important feature, actually, of the San Francisco rent ordinance.
But that's the same rule that applies for if you got a roommate. You can't charge your roommates more than you're paying for rent.
That's 100% right. Yep. It's the same concept carried over here.
Yeah.
Yeah. Okay. So that's pretty cool. Let's go on, I think, Megan, to the next slide. And this is one that I'm a landlord lawyer, so I represent owners, property owners, and landlords. This is really important. This was a bigger deal a few years ago. It's kind of less of a big deal now. I don't see this that much because I think the law is now relatively well settled in San Francisco. But at first, it was a big deal because there was a lot of, rogue short-term rental activity going on out there. And one of the ways that the ordinance cracks down on that is that when a tenant goes into the Office of Short-Term Rental and registers his or her unit, that registration is going to automatically kick out a postcard to the title owner, and that postcard is essentially going to say, "Dear title owner, your unit has been added to the registry, so you're on notice." Right? You as the landlord now know that your tenant has registered your unit on the short-term rental registry, and so then you got to decide what you're going to do about that, if anything. Okay. Let's go to the next slide.
Now, on my own personal tenant or place, for my tenant, I put in the lease, you may not Airbnb the units.
Yeah.
So that would, if I was to get that notice, that'd be pretty helpful.
Yeah, that's a really excellent point, Kevin, and it really segues into our next slide here. And that is, what can a landlord do if a tenant has registered the unit as doing short-term rentals? There's really two avenues. One, let me just give a plug for the San Francisco Apartment Association's form lease, because it's the gold standard in San Francisco. It's the one that I recommend that landlords use. It's comprehensive, it has all the disclosures that you'll need, and it has this language in here. You can check this box, and it prohibits people, or tenants rather, from doing short-term rentals if you don't want them doing this. And so, as Kevin mentioned, if you get a situation where you have a tenant who's doing short-term rentals and there's a lease prohibition on that, that violation of that lease prohibition can be grounds for an eviction. Okay.
Wow.
One of the, and how do you go about doing that? Well, you serve a 3-day notice to perform, covenant, or quit. Now, one of the challenges in this is that you can get into a game of whack-a-mole, right? Where you can serve the notice and then the tenant comes and says, well, I'm not doing it now. I've cured the notice within the 3 days. And then they do it again. And so you get into this constant, game of trying to chase them down and get them on that. I don't really see this so much anymore, but it was a real problem about 4 or 5 years ago. Let me also speak, there's one other way that initially that we were able to go after this issue, but the rent ordinance has changed just a little bit. And that is this: initially, when back in the bad old days, at the beginning of the discussion, I told you it was just a flat prohibition to do short-term rentals under the planning code prior to the ordinance. In those days, if we found out that you were doing short-term rentals, we could just slap you with a 3-day notice to quit. No opportunity to cure, just a 3-day notice to quit for illegal use. If you're using the property for an illegal purpose, like in violation of the planning code, that's a 3-day notice to quit. You don't have to give them an opportunity like you do in a lease covenant violation, where you give them the opportunity to cure the violation and prevent the eviction. But the rent ordinance was at or about the time that the short-term rental ordinance was adopted. They modified the rent ordinance, and so now essentially, instead of doing, on your first violation, you can't hit them with a 3-day notice to quit. You've got to hit them with a 30-day notice to cure or quit on the first violation. So, and it's the second violation. If they continue to do short-term rentals in violation of the ordinance, then on the second violation, you can hit them with a 3-day notice to quit. So essentially what I call it, and what most people refer to it, is the initial 30-day first bite at the apple rule. So you get your first bite at the apple. If you're a tenant and you're doing short-term rentals, and you don't have a certificate and you're in violation of the ordinance, the landlord can serve you the first 30-day notice to cure or quit, and then the second violation we can do a 3-day notice to quit. Okay, so the rules are a little bit more lenient. It's not quite the draconian forfeiture that it was.
Fair enough.
Yeah, and you know what? Honestly, again, this has been less of an issue in my practice. I see a couple of years ago there was a lot of this kind of, oh my God, they're doing Airbnb. Now, more often than not, what I see arising from short-term rental activity in the landlord-tenant context is nuisance cases. The neighbors are complaining about the comings and goings of transient guests. The transient guests don't treat the property like the owners do. This is particularly a case in like TICs and HOAs, homeowners associations.
Yep.
So that's a bigger issue there. But just the rank violations, I don't see too many of that. Okay, the next one is sort of hosting platform requirements. These are not all that interesting. This has kind of become sort of baked into the cake. The hosting platforms, you've got to tell everybody you've got to comply with the law. They've got to collect applicable taxes. They've got to verify that the hosts are registered with the planning department, and there are administrative and civil penalties for failure to comply. So, but again, this I think is relatively well established now. There's been litigation, and the law is getting more and more settled in this area. So I don't see too much on that on the housing platform. And that's all I got. I'm open to questions, Kevin.
Yeah, I forgot to mention at the beginning if people have questions, just to text in to the chat room there, and we'll share those questions with Michael. But I have a couple myself. So we talked about 30 days a couple times, and so what is the difference between renting to someone for 4 days on a short-term rental versus renting to somebody for 32 days? What happens once you start renting to somebody for 32 days?
Well, the 32-day issue becomes up in like SROs and so forth. But as soon as it's a risk, this is a really big risk. As soon as you put somebody into possession of residential real property and you give them a lease and you collect rent from, they're a tenant.
That's what I was.
Yeah, super scary. I've had situations, I can tell you a few war stories. Now, thankfully, they were outside the city, but I had a really big eviction on a holdover guest at a very, very pricey piece of property up in Napa Valley. Essentially, the family moved out to the area, not for vacation purposes, but because they had a convalescent family member who was seeking medical attention by a specialist in Santa Rosa. And they didn't leave. And it was okay in December and January when it was off season, but then they had a whole bunch of bookings, into the spring and summer, and it was, bad reviews, and it was chaotic.
Right.
Yeah.
No, I have a property manager for my Airbnb, and every so often someone will ask for a 31-day lease or something like that, and I'm just adamant, no, 28 is max. That's it. I'm not even going to touch on the 30. And
right.
but you can get this. I go, no, because it's always January when they want this. And they went, yeah, can I get a lease for 3 months or something like that? And I'm like, yeah, and you want it at January's numbers. I get that one. If the place is rented, 4 weekends or and that's it. That's all you're getting for January a lot of times. And so, yeah, you'd be tempted, oh, wait, I could charge a whole month. But then you get stuck with them, and you get stuck at that low rate for the whole year. And, I make a killing, even with all the COVID stuff I made a nice little killing on my particular Airbnb, and it's just a 1-bedroom place. But, I'm near a beach, and I'm, it's a tourist area, and it drives a lot of attention. And because of that, it's like, I know not to give that 30-day up. So it's always like a little thing. There's, same thing with these guests that you get. I'm kind of like very particular about, if they smoke or they have animals, that's a no, because I see what they do to the property.
Yeah, right. Yeah.
That part's really interesting. Yeah, no, in Pacifica where I live, the rules are similar to San Francisco's, but not as ardent. So it is possible to get a place. I've seen, we talked about this before the thing, where you're not supposed to rent out a room that can be rented to somebody. So if it's a auxiliary dwelling unit of any kind, where it's got a little kitchen, a bath, and a bedroom, that legally has to be rented. It cannot be Airbnb. And yet I see them do it all the time. And the only way around it would be if they live there and they're going on vacation and now they want to give it up for the 90 days, like you were talking about earlier. But I have a feeling those people are not doing that, that they're just taking advantage, and the city's not monitoring it as well as San Francisco would be monitoring it. San Francisco is over the top, right?
Yeah, they really monitor a lot. And Kevin, you and I were talking a little bit briefly about this concept prior to the webinar getting started, and I think it's an important point. Let's touch on it again now that we have a bigger audience here. And that is this: I see very frequently people come to me and say, "Well, Michael, I don't understand why I'm getting an enforcement action from the city, but my neighbor is doing exactly the same thing and they haven't gone after them. This is unfair. I shouldn't have to pay this penalty because my neighbor's getting away with it. You know, why is that fair?" And I tell them, listen, it's unfair. But it's a really important concept in the law to know that when you have an agency that has a discretion to enforce a statute, the fact that they make a discretionary decision to enforce against this person but not that person is not a defense for the person who's being enforced against. It is not.
When you get pulled over by a cop for doing 80 miles an hour, you say, but everyone else is doing 80 miles an hour, doesn't matter.
Exactly, which is why it's always better to be the shadow car and not the lead.
Absolutely. Absolutely. Make sure you're not the fastest guy on the road. It's just #1 rule. We talked about a little bit of a scenario where someone has a downstairs area. We were talking about this before the call, but someone has a downstairs area and they want to come in and, let's finish it off, and then we'll, add a separate door to the back side, and we'll add a bathroom and bathroom to the room, and now I can Airbnb the place. And I was explaining to them that's not going to be possible because, and then I even made the mistake of thinking, well, you could pull it and convert them into 2 extra bedrooms and make it part of your living area. But you were saying you might not even get that permit pulled because the short-term rental department is now part of the planning department, correct? The permit department.
Yeah, that's right. Yeah. So the Office of Short-Term Rentals is over there in the planning department, and they have access to all the building department and all that stuff. So they'll know. My experience is that the more separate that the unit is, the more likely the planning department is to deny the application.
Yeah.
It never ceases to amaze me how much that they know, right? So it's really, really crazy. I'll tell you my, you remember the television show The Odd Couple, Oscar and Felix? One was super messy and one was super clean. I actually had what I kind of jokingly refer to as the Odd Couple case. So I had 2 airline pilots, and one was super messy and one was super clean, but they were married and they had a duplex, and she lived in one and he lived in the other, but they were happily married. And the reason they did that was that she was super clean and he was super messy, and she just didn't want to live, day in and day out, it's messy. So they both applied to the planning department for short-term rental certificates, and they denied the super clean one. They were like, no, you guys are married, so you must live in the same unit. And it took the appeal process to basically prove the Oscar and Felix issue. And they both eventually got it, but I sat there in that case going, it's amazing how much Omar knows. Like, this guy knows a lot.
Yeah.
He's really smart. Yeah, but on a serious note, my experience with the office is the more separate the parcel feels, certainly if there's a separate entrance, that's likely to not pass muster with them. They're likely to deny that. And I've even seen it where you know, it's a whole separate part of the property, but you've got to go through the other part to get outside. I've even seen people have problems with that. So, you know, now here's the situation. You can appeal a denial, and I've helped some people with some appeals. I did. She's one of the best clients I ever had. She's honestly one of the most thorough, unbelievably over the top prepared people that I've seen. And she got denied because the planning department didn't think that it was her primary residence. And so she went out and she got statements from, like, it's not an exaggeration to say 100 guests put in declarations for her saying that she was always there and she was really warm and she this and she made breakfast, and it was just this amazing appeal. So you can appeal these adverse determinations at the planning department. Whether you're going to be successful, honestly, depends on the merits and just how hard you're willing to work. Yeah.
Are there
if you work
places that are shared space within the unit, that's okay to rent out in San Francisco then? Like you can rent out a bedroom within the space?
Yes, yes. I mean, look, here's what I would say. If your if your guest has to use the kitchen with you, more than likely that's going to be okay, because that's sort of one of the telltale indicia of a shared space. If there's a separate kitchenette, even if there's no separate entrance, but you have to walk through, if there's a separate kitchen or a separate kitchenette, more than likely I would say, I'm not gonna, if I'm in Vegas, I'm not putting my money on you. Yeah, I mean, it's just it's a discretionary thing with the planning department. But if your guest has to use the kitchen with you, then more than likely it's going to be, you're gonna be okay.
What is the definition of a kitchenette?
Well, there isn't really a definition of a kitchenette, but if you go into, and I don't have at my fingertips, like the planning code and the civil code, and if anybody really wants to follow up on this, and I'm always open to follow up with people. If you have a question about whether your space in your place is legal or will pass muster, then I'm happy to delve into the code with people. There are definitions of dwelling unit in the civil code and so forth.
Okay.
Yeah.
I do have a couple questions. So if the STR refuses to leave, how do you get rid of them before the 30-day limit?
If the short-term rental refuses to leave, well, that's really tough. You know, if you enter into a transaction where you enter into a lease and you take rent for exclusive right to possession of the property, guess what, guys? That's a tenant. That's a tenant. Yeah. So you have to evict them. You have to prove a just cause.
But if it's an Airbnb guest and all of a sudden now they're not leaving?
Yeah, you still have to go through the eviction process. There's no summary process.
Oh, really?
Yeah. Yeah, there's no summary process even for Airbnb type holdover guests. Yeah. There's no short term. You can't call the police. The police are going to come out and say, oh, it's a civil action. It's a civil matter. Take it up in the civil court. So you're going to be,
Wow.
yeah, you're going to be, yeah, there is not a carve out exception to that. Let me speak briefly to this. There is a concept under the law. It really kind of depends, frankly, on a couple of things.
Mm-hmm.
There's one exception where this might come up, and that is this. That is the lodger law, the single lodger law. Okay, in California, if you have a single lodger in your residence, you can bypass the unlawful detainer statute and get them out using the lodger law.
Okay.
The most important thing, though, guys, is this. What is a lodger? It's really, really nuanced definition. Essentially, a lodger is someone who is in possession, who's paying you rent, maybe week to week. That feels like a lodger. It feels a little different than the classic tenant, right?
Mm-hmm.
The crux of defining a lodger is that the owner maintains control over the entire unit. In other words, can you just walk into their bedroom when you want to? Or is this then separately set aside from them and you feel like you have to have permission to go in there. If you have to have permission to just walk into their room where they're staying, then it's not likely a lodger. So if you had an Airbnb guest and you made it clear that you had the right to just go into the bedroom that they might be staying at in, that's likely a lodger. But it, like anything in the law, it's a facts and circumstance type test, right? So it's a question of fact. You may get to the point where you have a jury question about whether this person was in fact a lodger or whether they were a tenant. If they were a tenant, they were entitled to proper notice. Now, so let's talk about that situation. This is an important exception to the just cause to evict provisions under the rent ordinance. And that is this: if you are the owner of the property, the landlord, and you are renting to one tenant and you share the same dwelling unit with the tenant, the same rental unit. In other words, they're renting a bedroom down the hall and they share the kitchen with you, and that happens a lot. There's a lot of that. Then you can terminate that tenancy on a proper notice, either a 30 or a 60-day notice, without having to prove a just cause. Now, if you're renting two separate bedrooms out, that exception to the just cause requirement goes away. So if you're having, just say, let's say that you're in possession, it's not really a lodger situation, or you're worried that you don't want to go down that road because you don't think you'll be able to prove that you had absolute control even over their bedroom. And you wanted to get rid of them anyway and they won't leave, then we could serve them a proper notice terminating that tenancy without having to state a just cause. If it's a single tenant in possession and still in that kitchen with you. Yeah.
A single person can't be a couple.
No, it can be a couple, a single tenancy. Right?
Okay.
Yeah, tenancy, but you wouldn't want to have like, group A in one bedroom and group B in another bedroom. That would not work, because then now you've got like now you could have got basically 3 separate dwelling units in the same residence.
And then where I was going with this was, if you say that, let's say they rent for 2 weeks and you say, well, I'm going to come in and clean midweek, that's giving you access to the room and therefore they would be a lodger.
Could be.
Could be.
It's one of those. It's like one of those granular things. And I can tell you this. I could tell you this. We could spend all night with hypotheticals on this point.
Right.
But the takeaway here is, if you're reaching to a situation where you've got to prove that somebody's a lodger, it's pretty rare. It's a pretty rare circumstance that I see a lodger. I've done lodger type situations, so I know them when I see them. But I've had a consultation with somebody a couple days ago about, whether somebody would be considered a lodger, and I said, I'm not liking it. It's just not going to feel like a lodger situation. It is there. It's important to know about it. But what I see as the lodger more than likely, Kevin, is like your high school friend came to stay with you, right?
Yeah.
And
that's what I was thinking.
And you store the linens in the closet in their bedroom, right? That you gave them out in the guest room, and you can still walk in there, and you still have control over that, and you still go in there, things that you use for the house. But if this room was kind of set aside for that person, the likelihood that a court or a jury is going to find that this was a lodger is pretty small.
And then you do landlord stuff all the time. So how hard is it to get these people out once you start the process?
Yeah. I tell you, I tell people all the time, doing an eviction it's a very difficult, drawn out, frustrating, and expensive experience. And that's when you have all the facts and law on your side. Right. And that's when you've rented only one room. You've been able to serve a notice, and you serve it properly with the assistance of a skilled, experienced lawyer. There's no defect in the notice. You lived in the same unit, so you didn't have to state or prove a just cause. You had a good process server that filed, and so on and so forth. You're still looking at months and thousands and thousands of dollars in legal fees.
Yeah, and that's if they take care of the place and don't destroy it also on top of that.
Yeah. One thing I should say about this is, if you ever get into a situation where you need to get somebody out of your property, you need a lawyer in California. It's just full stop. It's not possible. I've been practicing law now for 22 years, and I tell people I'm batting 1,000 on one proposition, and that is this: non-lawyers are not able to prosecute a unlawful detain or eviction action in California. The system is designed for you to fail without the assistance of a lawyer. It has to be perfect in every respect, or you have to start from the beginning.
Yeah, no, I've seen landlords get destroyed by tenants. And it just takes one bad tenant. And it's just, it's really sad when I see it and I hear the cases, because they usually come to me because now they need to borrow $150,000 to pay off the fine or the settlement with the tenant that never paid them rent in the first place, destroy the place, and oh, now I got to pay the money. It's like, it's just insult to injury. So I know that's what you do most of the time. The Airbnb is kind of the hobby stuff for you.
Yeah, exactly. The Airbnb type stuff is stuff, but my bread and butter really is getting possession of real property back. You know, our real that's really what we specialize in.
But it was after your presentation I suddenly felt more comfortable actually doing Airbnb. I have a little place over garage. I was like, okay, that'd be perfect. It's attached to the house. I can enter through my side or not.
Right.
You know, and because of that, I started doing it. But I did have to face, I had to go down to the city of Pacifica and fill out all the paperwork, and had to pull out a business license and all these other little steps that you have to do, and talk to your insurance company and whole process. And I have a property manager that does it. I don't talk to the tenants. He does all that. He comes in and cleans between each client. So I just deal with the fun part.
I'm a big fan. I think it's great. I really do. I do think it's great. My biggest thing is I just tell people, listen, it's just so much easier to do it when you're in compliance with the law. And you don't have the stress of sort of trying to sneak around and game the system a little bit. If you can actually do it, and I've got friends who have very successful, basically side businesses. I'm a big fan of it. I think it's great. And the way that it's gone now is that it's the requirements for compliance are fairly well understood in the city now. My sense is that the issues for compliance and whatnot have gone substantially now that everybody kind of knows what the rules are. And you can do it, and you want to do it. It's a great opportunity.
Are there some special rules for healthcare workers during COVID? Because I talked to somebody who's saying that if he puts it up as a special place for healthcare workers, the city was more lax on it. Is that true or not true?
That's a great question. I actually don't know the answer to that question. If that's true in San Francisco, I would imagine one, and I'll use this as a plug, is that I haven't come across that, but the Office of Short-Term Rentals website is a wealth of information. So my sense is that if that is actually true, there'll be a little squib on that at the OSTR's website.
And we do have a bunch of people here from across the state. So any general rules for Airbnb? Just, I know like there's certain like little towns like Hillsburg, you're not allowed to have an Airbnb unit, or they really frown. But what about other areas where there's like hot pots?
Yeah, I'll just tell you, I just did an Airbnb myself down in Palm Springs about 3 weeks ago, and it was very interesting, the compliance requirements. I had to send them a copy of my driver's license and fill out, I can't remember exactly what the form was, but there was a special form you had to fill out, send in your driver's license. And so there are all sorts of different rules, all sorts of different cities, Palm Springs. I think that there's one up in I think that there's an Airbnb type rule up in Guerneville, short-term rental rule. And so what my usual advice is that find somebody in the local jurisdiction, somebody like me who does landlord-tenant type legal work, because they're more likely to be pretty much in tune with the ordinances. Find out what the rules are and follow those. I will say this: San Francisco kind of led the way in doing.
He's from here, right?
ordinances. Yeah, the San Francisco ordinance is one of the, if it's not the first, I think it's the first in the country, but it's certainly one of the first, and it's one of the most well established. And a lot of other, local jurisdictions have passed Me Too statutes. Just basically ours is going to follow San Francisco with the slight variations.
Yeah, so there's a story I tell when I'm teaching mortgage law rules to other mortgage people is how I learned about how powerful San Francisco was when I went to Finland and they were following California laws. I'm like, why are you following California laws here? Like, because they set the highest and best standards and we had nothing else to follow, so that's what we're following. And I was like, wow. And then I realized where the power is coming from. You look at the power center. When we go to Washington, D.C., the Northern California goes to D.C. From CAMP, California Association of Mortgage Professionals. Southern California will get maybe 10 people, maybe 40% from Southern California, and then the rest, 60% come from California. And of California usually represents 50% of all the people from around the country that show up. So yeah. California really dictates on rules and regulations, so it's quite interesting. But,
well, and this is digressing a little bit, but the federal rules of evidence are based off the California rules of evidence, and there's a reason for that.
Well, same thing. All the federal laws on mortgages came out of California also.
Yeah.
Anyhow, we've actually hit the hour. I want to thank you again. So Michael McLaughlin, a great landlord defense attorney in San Francisco. If you ever have an issue with the landlord issue, Michael McLaughlin is a great guy. And thanks again. And this video will be recorded, so people want to check it out. And we're going to see if I can post it up on the state side. I'll know this is a local chapter one, but I think we can post it up on the state one also. And so people, Michael, if you have people want to refer to it, you might be able to pull it off and we can share it.
Yeah.
Thank you. Have a great evening, and we'll see everybody around.
You too. Thanks again, Kevin. Really appreciate it.
Oh, you're welcome. Take care.
Okay, talk to you guys soon.